Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Christina Ma, and today's episode is 1, 2, 3 strikes you're out. Part 2 of a 2-part discussion with the defense lawyers in the 3-part chicken price fixing trials. Try to say that 3 times fast. In last week's episode, we spoke with 2 of the defense attorneys representing chicken executives recently acquitted of price fixing allegations made by the Department of Justice to learn more about the 3 trials and their evolution. In this episode of Our Curious Amalgam, we've brought Rick Kornfeld and David Beller back to discuss some of the trial strategy and how the case was won. Joining me today is my co-host, Jaclyn Phillips. Hey, Jaclyn.
Hi, Christina.
So can you briefly introduce our esteemed guests, Rick Kornfeld and David Beller, again?
Absolutely. I hope no one missed last week's episode, but just in case you did, I will remind everyone that we have Rick and David here. Rick is a former federal prosecutor and seasoned trial lawyer. He specializes in white-collar criminal defense and also does corporate compliance and internal investigations. David was a former Colorado State public defender, and he continues to specialize in criminal defense, representing individuals and organizations in state and federal criminal investigations, jury proceedings, and more. Rick, David, and their partner Kelly Page led the litigation team that secured a full acquittal for their client, a poultry industry executive, after 3 criminal trials brought by the DOJ Antitrust Division. So we're excited to get into part 2 with you, where we're going to discuss a bit more about trial strategy and your backgrounds and advice for lawyers who, want to do what you do. So I'm going to start with David this time. And can you tell us a little bit about your background and trial experience and, how you think that all has factored into where you are today, having secured this acquittal that we're talking about?
Sure, and thank you so much for having us back. So I have a very unique background compared to most antitrust lawyers, and that is I started as a state public defender here in the Denver metro area. And so as a state public defender, of course, you get a ton of trial experience. And a ton of trial experience, oftentimes litigating factual scenarios that are just not particularly sympathetic to the client. And so, while, antitrust lawyers have, I guess, typical antitrust lawyers have phenomenal expertise in antitrust laws, just by nature of the practice, there isn't always a whole lot of actual in the courtroom trial experience in front of a lawyer. And so my particular situation, I think, gave me a unique set of skills, unique to the larger trial team, that allowed, I think, for a really nice working situation.
And Rick, you were a former federal prosecutor. So, how does that play into your experience and these trials?
Well, I mean, my background is certainly the more traditional, I think, for these types of cases. And I was in AUSA in Chicago starting when I was 25 years old. So I literally grew up in federal court and remain more comfortable in federal court. And the antitrust work, up until several years ago, Colorado is not exactly the epicenter of antitrust. Now it apparently is, not just the chicken trials, the DeVita case recently, but really, this work is really an extension of some of the general white collar work that I and my colleagues have done. And there's also been an increase in state antitrust enforcement, as there have been in many other states, particularly with Democratic attorney generals. Our attorney general, Phil Weiser, is a former high-ranking antitrust division lawyer in the Obama Justice Department. So Phil has a background, and we've done a bunch of that work in state court as well. So it seems like in the last 4 or 5 years, many roads have led us to the antitrust work, and really sort of more of a natural extension of a lot of the work I've done in the past, both as a prosecutor and on the defense side.
That kind of brings me to my next question. You both, antitrust wasn't, the bread and butter of your practice, and you're now in a forum where antitrust, maybe, there weren't antitrust cases in that court every day, and you're talking to jurors. And antitrust, I think it's fair to say, is notoriously complex. So for having that background for this case, what was your approach to distilling these issues and being able to tell a clear story to the jury as you were presenting these cases? So
you're right, Jaclyn. Antitrust is not the most easily digested or easily understood by jurors. And as good trial lawyers, you also have to be really good storytellers. You can have an absolutely phenomenal and amazing and very technical defense that is complete and total, absolute innocence on behalf of your client. But unless the jury understands that, unless the jury can really sort of process both the facts as well as the law, a hyper-technical defense does little for your client. And so we had the incredible insight in this case of Rick's wife being a teacher and a librarian. And so she also became an unwitting strategist for us, and had a great idea of introducing us to a couple of individuals who train teachers. And we ended up hiring them, consulting with these individuals, and having them go through what we believed to be our jury instructions, and asking them if this was your sort of recipe, if these were your instructions and you had to teach these to high school students, how would you go about doing that? And they really assisted us in creating a rubric that we believed was going to be useful for our messaging and for our storytelling to the jury. It was the first time, at least in my career, that I had ever consulted with teachers for purposes of preparing for trial. But it was an exercise that was so valuable. I don't know that I'm ever going to try a case without consulting with teachers again.
Yeah, that really worked. That really worked out well. And I think my wife, Julie, there was some self-interest involved because she was getting tired of the chicken case as well. But it really grew out of, I think, our frustration. On the defense side, you're doing a good job if you hang a jury in federal court. And you're doing a really good job if you hang a jury twice in federal court. But at the same time, we were frustrated. We, the entire defense group, we knew the evidence wasn't getting any better for the government. So the only thing we could really change, other than potentially putting the defendants on, we weren't going to really change our evidence. It was more changing the presentation. In our frustration, we talked in the last episode about the central element being an agreement, an illegal agreement. And our frustration was that under the law, if you can't find an illegal agreement, you're done. You, the jury, are done. You have to acquit. And we felt like the jurors, some of the jurors that hung to convict, were essentially kind of crossing their arms and saying, well, I know the government didn't really prove up this thing, but they were talking all the time, so something must have happened. So really figuring out ways really to teach the jury instructions and to teach the concepts. What is an agreement? What is a reasonable inference under the law? What is the difference between circumstantial evidence and an assumption? And we really wove those themes not only into our presentation, but to the great credit of our colleagues, some of whom have a background in teaching as well, very open-minded to this approach. And we were, I think, able then as a group to put forth a much more coherent theme, not just in opening and closing, but in our cross-examinations, that all centered on the focus on the jury instructions and what we felt and believed the government's case lacked. So that was incredibly eye-opening because we're all trained, of course, the same way, and teachers are trained in a completely different way. And it's a great lesson to go to someone who is trained in a different way and to brainstorm with that person.
Another way that people often prepare for trials, right, is to do a mock trial, have mock juries, to get at some of the things that you got with these teachers. Was that a component of the prep that you guys did? If so, how did that inform your strategy? If not, why not?
Absolutely. That's something that we did in this case. But at the end of the day, even a mock jury is, you're really just sort of litmus testing different theories and then listening to feedback. And really, it's the value of that feedback that's incredibly important. And so while we did that in this particular case, and that's something that we've done before and would do again, I think that's a little bit different than the exercise that we did with the teachers, which is saying this is the law. And we believe very much that we win on the law and should have won on the law. And so the only thing that we could really process and understand from trials 1 and 2 and hung juries is that the jury instructions are written by lawyers. They are delivered to the jury by a lawyer. And then there's lawyers standing up and arguing them. And so how do we really use language that is not lawyerly, that is really easy for a jury to understand and sort of absorb the concepts using casual, sometimes colloquial language, such that they're able to actually plug the facts into this. And so while there's value in the mock jury exercise, I think that is different and apart from really being handed and taught the language so that the jury had an understanding of the rubric and could really process and understand and apply the law despite the complexity of the language of the instructions.
And one of the lessons learned, I think, one of the many lessons learned is we're trained advocates and we're trained storytellers. We're not trained educators. David and I have both done a lot of teaching, but it's teaching to lawyers. That's very different because we speak a common language. And what we got from the teachers wasn't, quote unquote, dumbing it down or even simplifying it. It was teaching it. So my favorite example is they said to us, okay, this is about a conspiracy. How do you describe a conspiracy to a jury? And for 25 plus years, I've said all a conspiracy is an agreement among 2 or more people to break the law. As a lawyer, I think that's a pretty digestible explanation. They immediately said, well, would it be accurate to say, is it the same as like, I'll do it if you'll do it? And we were like, whoa, yeah, like that's so much better. That came into our cross-examinations. That came into our closings. I mean, it's simple little things like that that make things, that make your advocacy much more effective because you're teaching a very difficult concept in a very easily understandable way. And that's a whole different thing than all the stuff you hear about, well, they're visual learners and they're auditory learners. Teachers have been involved in jury consulting in that regard, but this was really just the simple question. If you were teaching whatever it is, reasonable doubt, how would you teach it to your students? And it's very different than how we as advocates, at least how we as advocates did it in the first 2 trials. And I think the proof is in the pudding. It worked.
So with cross-examination questions, to Rick's point, a simple question was, sir, in this communication, was it ever said, I'll do it if you'll do it? Answer, no. And so a really simple way of breaking that down with very common, easily understood language, as opposed to getting into the word agreement or trying to dissect the agreement. It was that very simple, straightforward question that ended up being a theme throughout the entire trial.
And to David's point, that was super effective because in trials 1 and 2, the insider kept saying, well, you there's no evidence of an agreement. You never agreed. We kept using the verb, the noun. And his response was, well, it was my understanding. So we're into this, this farcical kind of lawyers debate. Is an agreement an understanding? Is an understanding an agreement? And in trial 3, where we've stepped away from all that, I'll do it if you'll do it.
That's so interesting. We had an episode a while back, and it was with jury consultants, and she was explaining the importance of diversity. And there's also diversity in background, right? You dealt with these teachers who did something different in their professional life than you did, and then they gave you this insight into how you could put on your presentation that you may have not had you not had a teacher, on your team. So that kind of gets me into these other questions, we wanted to talk to you about today. And we talked amongst ourselves, about your takeaways from trial with respect to who you were looking at in the courtroom and what you noticed about the lawyers who were in the room. And what are your thoughts on that? David, I'll start with you.
Yeah, I think antitrust generally, white-collar defense generally, I think it is, certainly from a defense perspective, is historically made up of white men, period. What was very surprising to us, and that is in trial 1, we had mostly white men representing 10 white men. Very little sort of gender diversity. We had decent age diversity, but certainly very little persons of color who made up the overall defense team. And while both me and Rick have represented many individuals of color and are very comfortable choosing a jury, and discussing race and discussing gender. This is a situation where one of the jurors raised their hands and pointed out the fact that there were no people of color in the courtroom. And so very surprising to us, and that is I ended up doing a bit of a race focused voir dire, despite having nothing but 10 white men who are charged with a crime. And I think that that's a really important and significant insight. And that is that there is a place amongst the antitrust world for women. There's a place in the antitrust world for persons of color and for age diversity, because it's not just enough for us to say this is something that is important to us as a bar, it's important to us as people. But rather jurors are now expecting it, and jurors are now talking about it importantly. And so everything that is important in diversity is also important specifically to the client and for us to be giving a voice to these different perspectives and these different backgrounds, whether that's from a federal prosecutor like Rick, whether that's from a former public defender, whether that's from a woman like Kelly, a younger woman like Kelly. Having some of this diversity of thought and background is so incredibly important because jurors now expect it. They expect to hear about it. They expect to see it. And they expect us to acknowledge their own diversity and be able to address it. So there's a place, I believe, in antitrust for this. And I think that the time is right for other individuals of diverse backgrounds to be speaking up and really finding a place in the antitrust world.
Yeah, that's great, real world insight to why this is all so important.
And it's interesting, Jaclyn, excuse me to interrupt you, but for a juror to raise her hand and point out that it dawns on her that there are no persons of color in the courtroom, including, by the way, on the jury. for her to say that. And so immediately it turned into a question of, well, tell me why that is an observation. What are you thinking? What does that mean to you? What are you seeing? And to have that discussion, jurors expect us to have that discussion. Jurors expect diversity amongst themselves as well as amongst the individuals in the courtroom. And so why that came to her, I don't know, but I love the fact that she actually raised it. And I love the fact that we are at least educated enough on it to be able to discuss that with her. But it's something that we need to be more comfortable with. And we really need to be recruiting other individuals of diverse backgrounds to be a part of this bar.
And also giving those folks the opportunity so that when you're in federal court in a major trial, that the younger members of the team can get up and meaningfully participate. It's not enough to have somebody sitting at the table, even if in fact that person is an integral part of the team, because the jury doesn't see that. So, we both, David and Kelly came out of the PD's office, serious on your feet experience. I came out of DOJ and I tried more than 20 cases in 5 years, which these days is a career as an AUSA. It was just a very different time. But, neither of us can really speak to big law. And to the credit of many of our colleagues, many of the teams did provide their younger lawyers with opportunities to stand up. But that's just mission critical for, not only for all the reasons that we're talking about, but also for the client to have confidence in the team, so that whichever lawyer is getting up and doing whichever witness, the client knows that the client is in good hands. Because if you're the client, you just want the best defense possible, and you're probably less attuned to some of these issues being in that position than others in the courtroom are. So I think that, however that works, however that can work, to get folks that on their feet experience, so that if and when there's an actual trial in federal court, the people can meaningfully participate and the jury can see that and the clients can be confident in that. That's absolutely critical.
Yeah.
Did you get a sense of how the DOJ responded to that jury inquiry? Obviously, the statement probably applied both to the defense and the prosecution. Did you guys converse with the DOJ about it, or do you have a sense of how they responded or reacted to it?
We didn't. And the reason we didn't is because when that question came up, the Department of Justice had already done a very limited voir dire. The judge gave each side 40 minutes for voir dire. I think in trial 2, the Department of Justice spent 12 minutes of their 40. And, that by no means is a criticism. What that is, however, is to say that there's an opportunity for us to be able to communicate with the jury and really have an understanding from the jury as to what their challenges are, or what their concerns are, and to be able to address those throughout the trial. So in this situation, what we know from sociologists and just generally sort of the mentality of society in general is that gone are the days where juries and really anyone is deferring to the oldest, whitest male on a jury. We are all sort of empowered, regardless of gender, sexual orientation, age, race, whatever it may be. We are all empowered to have a perspective and to really voice that. And I think what we are seeing as attorneys is that jurors are empowered to have their individual voice, and they no longer necessarily expect to be lectured to by, sort of this historical profile of what we believe a defense lawyer, an antitrust or criminal defense lawyer to be. And the bottom line is really good defense teams need to embrace that diversity, not just because it's the right thing to do, but because jurors expect it. And defense teams should, in many ways, reflect that jury pool, because jurors receive information from different profiles and different perspectives. And we need to make sure that on behalf of our clients, we're delivering that as much as we can.
I also, going back to, this case and your client, we spoke in our last episode about the kind of unique emotional turmoil that was going on with your clients, and I'm sure among the defendants. And you have the situation where you're adjusting your strategy and things are changing. And I guess this is kind of a wrap-up question to all of this. How did you manage that? How did you manage this unique situation you were in with your client on top of, the day-to-day of having to prepare for this trial and be adjusting to everything that was going on?
I think something that is incredibly, is something that me, Rick, and Kelly really pride ourselves in, and that is having empathy for a client. We are representing not just a legal position or a legal strategy, but we have a human being in front of us who has a family, and he has employees, and he has a ton of pressure on him. And so I think something that makes us, I believe, really good lawyers is we never lose sight of the fact that there's a human being and people who love him and people he loves around him. And so law school does not train empathy. Law school doesn't teach empathy, but it's something that I think we very much pride ourselves in. And so really understanding that this is him and his life is something that we never, ever lost focus of. We never started a day or ended a day without asking him how he's doing and meaning it. And so I think simply being there and having our client know that we cared about him first and foremost is something that lawyers cannot lose sight of. Now, for the more technical aspect, I'll turn it over to Rick.
Well, I was going to say we were very lucky and very blessed to have one of the most gracious people I've ever dealt with personally or professionally as our client. And he was someone he didn't know us, but he trusted us to do our job. And he was engaged, but not a micromanager. And he was obviously a tremendous resource for us. So, we, I think, also look at our client as a part of the team. And one thing I always say, having been a former prosecutor, on the defense side, I don't have the FBI anymore and all these agencies and the grand jury. And frankly, I kind of miss those things. It would make getting information a lot easier. But what the advantage we have is we have the client, and no one is ever going to be smarter about the way his business operates in this case than us, because we have that resource and the government doesn't. And his patience with us, he took us through the plant. He answered 1 million questions at all hours, text, email, phone. And that was just a tremendous advantage to us. And utilizing that resource and making the client's the client, but the client is also an integral part of the defense team. And I think that is particularly in a complicated case where we want to know the industry better than the government. That's how you have to approach it, I think.
Great. Well, David and Rick, thank you again for your time today and last week. But before we let you go, we do want to ask you our sort of final segment that we ask all of our guests, the Curious Hat.
And now it's time for the Curious Hat.
So who should I start with? David, can you pick a number 1 through 10?
7.
7. Okay, so tell us about a teacher or a mentor who had a major influence on you.
Boy, I would, as cheesy as this may be, I will say Rick Kornfeld, and let me tell you why. As a criminal defense attorney, as a public defender, I'm inherently, I think, trained to be somewhat skeptical of prosecutors. And having worked with Rick now for 15 years, is where we talk about diversity and inclusion. Diversity doesn't necessarily just include my own perspective and what I think is absolutely right, but also his perspective from a prosecutorial standpoint in terms of how he asks questions, what his sort of some strategy that he may have, a perspective that he may have that is just completely and totally different than mine. And so diversity is not always one of something that you can see, but diversity is also diversity in training. And so I think that I am a much better lawyer having practiced for 15 years with somebody who has a different perspective and a different training than what I do. And so I think it's actually made us a better defense team, and certainly has made me a better lawyer. And so now the pressure is on Rick to say that I... the person he's learned from. I'm just kidding. But no, truly, I think that's the answer that I would give.
Well, Rick, you've clearly learned from your wife in terms of how to be a good teacher, and David is the apt pupil. So, Rick, your turn. Number 1 through 10, but not 7.
I'll go with 8.
8. Okay. How would you spend the perfect weekend?
Oh, that's easy. That's easy. I got the easy one. David got the hard one. We spend it in the mountains and doing whatever the weather and the current conditions will allow. So we have a place up in the mountains that we retreat to and ski and hike and cycle and hang out and read. If you're married to a librarian, you read a lot. And just getting away from, trying to get away from work. That was a bit challenging during the chicken case, but I think all of us worked hard to give each other breaks along the way. So the mountains are my literal and also kind of ephemeral retreat.
Great. Well, again, Rick, David, it was a pleasure having you on. And to our listeners, thank you for listening to this episode of Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.